So the first section, the Section 45 adoption of bylaws. So Section 45 explains the process of adopting the bylaws of a corporation. Bylaws act as the corporation's internal rules guiding how the organization operates. So to adopt bylaws, there must be an affirmative vote of at least a majority of the outstanding capital stock or a majority of the members in non-stock corporations. So the bylaws must be signed by the stockholders or members. A copy must be kept in the principal office of the corporation for inspection. Most importantly, the bylaws only became effective once the SEC issues a certification that they comply with the law. There is an exception. Bylaws may already be adopted before incorporation as long as they are approved and signed by all the incorporators and submitted with the articles of incorporation. Additionally, for certain regulated industries such as banks, insurance companies, public utilities, and educational institutions, the SEC will only accept the bylaws if accompanied by a certificate from their appropriate government agency confirming compliance. So let's move forward to Section 46, Content of Bylaws. So Section 46 lists the minimum content that should be included in a corporation's bylaws. So this ensures clarity and order into internal operations. The bylaws should specify the time, place, and manner of calling and conducting meetings, the procedure for notifying stockholders or members, quorum requirements, and how voting will be conducted, the use of proxies in meetings, the qualifications, duties, and responsibilities of directors or trustees, including guidelines on compensation, how officers are elected and their terms of office, penalties for violations of the bylaws. For stock corporations, the process for issuing stock certificates, any other rules needed for the proper and efficient conduct of corporate affairs, including measures promoting good governance and anti-corruption. So in summary, Section 46 ensures that the bylaws contain complete and organized rule for the corporation's internal operations. And for the last section, Section 47, Amendment of Bylaws. So, Section 47 explains how a corporation may amend or repeal its bylaws or adopt new ones. So, to amend bylaws, a majority of the board of directors or trustees and a majority of the outstanding capital stock must approve the changes during a regular or special meeting. A stockholder who owns at least two-thirds of the outstanding capital stock may also call a meeting specifically to amend the bylaws. So, the power to amend may be delegated to the board, but such delegation can be revoked at any time by a majority of stockholders. So, just like with adoption, amendment bylaws only become effective once the SEC issues a certification confirming that the amendment complies with the law. So this section ensures that any changes to the bylaws are made legally, properly, and with adequate approval. So that's all for the Title 5 bylaws.
Title 6 of the Revised Corporation Code explains how corporations hold meetings for their stockholders and directors to ensure proper management and transparency. There are two types of meetings, regular and special. Regular meetings are held on a scheduled basis, like an annual stockholders meeting or a monthly board meeting. These are for discussing the corporation's regular operations and updates. Meanwhile, special meetings are called when there is an urgent or specific matter that cannot wait for the next regular meeting. Both are important for corporate governance and decision making. Regular meetings of stockholders or members are held every year. The date is set in the corporation's bylaws. But if the bylaws don't specify a date, then the board can set any date after April 15 of each year. Notices can be sent through email or other ways approved by the SEC, so everyone gets informed. During regular meetings, the board presents important information to the stockholders or members. This includes the minutes of the last meeting, including how voting was done, what was discussed, and who attended, a list of stockholders or members, and their voting rights, the corporation's performance report, and any major changes in the business strategy, the financial report for the previous year with the audited statements and risk assessments, an explanation of the dividend policy, why dividends were paid or not, the profiles and attendance of directors or trustees plus their training, compensation, and any related party transactions. In short, everything a stockholder or member needs to stay informed and protected. Special meetings, on the other hand, are held anytime they are needed, such as for urgent matters. At least 1 week's written notice must be sent to all stockholders or members unless the bylaws says otherwise. Members can also propose to hold a special meeting and suggest agenda items. Notice of meetings can be waived, meaning a member can agree to attend even without formal notice. However, general waivers in the bylaws are not allowed. Also, if a person attends the meeting without objecting at the start, it means they've accepted the notice. If there's no one authorized or the authorized person refuses to call a meeting, any stockholder or member can ask help from the SEC. The SEC can allow that person to call the meeting themselves as long as proper notice is given. Before a meeting, the stock and transfer book or membership book is temporarily closed. This helps finalize who has the right to vote. The books must be closed at least 20 days before the regular meetings and 7 days before the special meetings, unless the bylaws require a longer period. If a meeting is postponed, a written notice stating the reason must be sent at least 2 weeks before the new date, unless the bylaws say otherwise. Voting rights can be exercised in person, through remote communication, or in absentia, meaning you can vote even if you're not physically present. The SEC will issue the detailed rules for online or absentee voting to ensure fairness. According to Section 50, all regular and special meetings must be held in the principal office of the corporation, as stated in its Articles of Incorporation. But if that's not possible, the meeting can be held in the same city or municipality where the principal office is located. For companies in large metropolitan areas like Metro Manila, Metro Cebu, or Metro Davao, meetings can be held anywhere within that metro area. Each notice of meeting must also include important attachments, such as the agenda, what topics will be discussed, a proxy form, so the members who can't attend may authorize someone to vote for them. If remote or absentee voting is allowed, the requirements and procedures for that, and if the meeting includes the election of directors or trustees, the process and requirements for nominations and elections. These attachments make sure everyone is informed and able to participate fairly. Lastly, Section 50 states that even if a meeting was improperly called or held, all actions done during that meeting are still valid, but only if all stockholders or members are present or represented, and no one objects at the beginning. This rule prevents technical issues from invalidating meetings where everyone is already present and agrees to proceed. Section 51 defines a quorum, which simply means the minimum number of people or shares needed to hold a valid meeting. For stock corporations, it's the majority of the outstanding capital stock, and for non-stock corporations, it's the majority of the members. Section 52 of the revised Corporation Code focuses on the meetings of directors or trustees and the quorum requirement. This section basically sets the rules on how the board conducts its meetings and makes decisions. Once there's a quorum, any decision approved by a majority of those present becomes valid. However, when electing officers, we need a majority vote from all the members of the board. The law also requires regular board meetings to be held every month unless the bylaws provide otherwise, while special board meetings can be called anytime by the president or as provided in the bylaws. Meetings can take place anywhere in or outside the Philippines, and the notice should be given at least 2 days before the meetings. One important modernization in this section is that board members can now attend and vote through remote communication, such as video conferencing. However, they cannot send a proxy to vote for them. Lastly, if a director has a personal interest in the transaction, he or she must refrain from voting to avoid conflict of interest. Section 53 states that the chairman presides at meetings, and if is absent, the president steps in, unless the bylaws say otherwise. This ensures meetings are orderly and someone is always authorized to lead. Section 54 clarifies who can vote when shares are used as security. Even if a stockholder pledges shares as collateral, the stockholder still keeps the right to vote unless they explicitly give this right to the creditor in writing. It also allows court-appointed representatives like executors and administrators to vote without needing a proxy. Lastly, Section 55 deals with jointly owned shares. Normally, all co-owners must agree on who will vote the shares, unless they sign a written proxy. But if the shares are classified as and or ownership, then any one of the co-owners can vote or appoint a proxy. Overall, these rules protect order, clarity, and fairness in corporate decision making.
Innovation. Section 56 talks about the voting right for treasury shares. Treasury shares are shares that a corporation has purchased back from its stockholders. Since the company already owns these shares, the law states that treasury shares do not have any voting rights. This means that as long as the shares remain in the treasury, they cannot be used to influence elections, decision, or any voting outcome in the corporation. The purpose of this rule is to prevent the corporation from using its own shares to control or manipulate the vote. It ensures fairness among the real stockholders who continue to invest and participate in the company. Now, moving on to section 57, which is about the manner of voting, this section explains the different ways stockholders or members can cast their votes during corporate meetings. Traditionally, voting was done only when people were physically present. However, with modernization and changing circumstances, the law now allows three official methods of voting. First, stockholders can vote in person. This means attending the meeting physically and voting directly. Second, they can vote by proxy. A proxy is a written authorization that allows someone else to vote on behalf of the stockholder. A valid proxy must be in writing, signed by the stockholder, and submitted to the corporate secretary before the meeting. Unless the proxy form says otherwise, it is only valid for that specific meeting. Also, no proxy can be elective for more than 5 years. This rule prevents long term misuse of voting authority. Third, stockholders may vote through remote communication or in absentia. This includes online voting, electronic voting, or other approved digital platforms. This method is very important today because it allows stockholders to participate even if they cannot be physically present due to distance, work, health reason, or emergency. However, remote or in absentia voting is only allowed if it is written in the corporation's bylaws or if it is approved by the majority of the board of directors. Also, for a vote to be counted, the corporation must receive it before the tally of vote is finished. A stockholder who votes remotely or in absentia is also considered present for purposes of quorum. This means that even if they are not physically present, they still count toward the minimum number of attendees needed to officially open and conduct the meeting. Section 57 also gives corporations the responsibility to establish clear rules and procedures for remote voting. This includes setting reasonable requirements based on the company size, the number of stockholders, and its structure. This rule ensures that voting remains secure, transparent, and accessible to all members.
Section 58. Voting Trust. What is voting trust? It is a tool for shareholders to temporarily transfer their voting rights to a trustee to consolidate power and vote as a single block.
The trust is strictly limited to 5 years. It can last longer only if it is required for a loan, but it must end immediately when the loan is paid. Also, it must be notarized and filed with the corporation and the SEC. If not, it is void. The original stock is cancelled and new certificates are issued in the trustee's name for voting purposes. However, the shareholder still owns the economic value and receive a voting trust certificate which they can sell. In short, it allows for a temporary and unified voting power under the strict legal condition. Section 59. Any contract for the acquisition of an issued stock in an existing corporation or a corporation still to be formed shall be a deemed subscription within the meaning of this title, notwithstanding the fact that the parties refer to it as a purchase or some other contract. Think of this as your promise to buy, even if you just sign the contract and have not paid a single peso, you are already legally obligated to buy those shares. So your word is like your bond from the moment you sign. Section 60. Pre-incorporation subscription. This is for the people who promise to buy shares even before the company is officially formed. This promise is irrevocable for at least 6 months. Why? It is to make sure that the company has a stable base of capital and subscribers can't back out easily. We are now to the third section for this Title 7, Section 61, Consideration of Stocks. You can pay for shares with just anything. You are allowed to pay with cash, with property like land or patent, with money from the company's surplus, or with services you have already finished. On the other hand, you cannot pay for shares with services that you will do in the future. The law wants real, present value of the shares. Also, the company cannot sell you a share for less than its official price, and that is illegal, and it's called watered stock. So later on, we will discuss what does it mean. What does watered stock mean? Let's move forward to section 62, certificate of stock and transfer of shares. The proof of ownership is the certificate of stock. It is like the title to your car. It must be signed by the top officers and sealed by the company. To sell your shares, you must do two things. First, hand over the certificate. Second, sign the back of it or endorse it. It is also crucial for the sales to be officially recognized by the company. It must be recorded in the company's official books. Without this recording, the company still sees the old owner as the legal stockholder. Now let's talk about the Section 63, issuance of stock certificates. Why is this non-negotiable? If we allowed a certificate to be issued for a partial payment, the shareholder could sell that certificate. The buyer would get the shares and the transfer would be recorded. If the original subscriber later defaults on the rest of their subscription, the corporation loses its leverage. It prevents the corporation from being able to fully recover the unpaid balance because the shares are already in someone else's hands. So the Section 63 is a vital protection for a corporate capital and the creditors who rely on it. Section 64. Liability of directors for watered stocks. As I've mentioned earlier, what is watered stock? It is stock issued for a consideration that is less than its par or issued value. It is a public lie about a company's financial health. So the Section 64 is so powerful because it imposes personal and solidary liability. A director or officer is liable to a corporation or its creditors for this shortfall in value if they first consent to a discount. Like for example, they issue a 100 par value share and consideration for 50 pesos cash. So, very wrong. Second is the consent for overvaluation. Like for example, they accept property or services that are fraudulently overvalued. And third, and the most important point, if the director knew about it, the insufficient consideration and did not file a written objection with the corporate secretary, they are all held liable. In the eyes of this law, silence is complicity. Now let's move forward to the last slide of my presentation, which is the section 65, interest on unpaid subscriptions. If you promised to pay for your shares but were late on the payment, the company has the right to charge you interest on that unpaid amount. This interest rate can be agreed upon in your original contract, or if not, the law will impose the standard legal rate, which is the 6% per annum. It is a way to incentivize stockholders to pay up on time and keep the company financially stable.
The Section 66, the payment of balance of subscription, ensures that stockholders fulfill their financial commitment to the corporation. Since when someone buys shares in a corporation but doesn't pay the full amount yet, the board of directors can require them to pay the remaining balance, which is called unpaid subscription. However, if the stockholder, the one who buys shares, doesn't pay on the due date, then the whole balance becomes immediately due, and the stockholders must pay the interest at the legal rate or the rate stated in the contract. Additionally, if the payment is not made within 30 days, their shares becomes delinquent or unpaid and penalized, and it will be at risk of being sold. That's why Section 66 maintains fairness and financial discipline among stockholders. Now, in Section 67, it outlines the procedure for selling delinquent stock or the shares that the stockholders fail to pay for on time. Although delinquent stockholders can still settle the payment if he or she pays the balance due, interest, and the cost before the sale. So once the shares become delinquents, the board of directors can order to sell them at a public auction. Then the board will issue a resolution or written agreement stating how much is owed, plus interest and expenses for said shares. Also, the sale must occur 30 to 60 days after the stocks become delinquents. After that, a notice will be sent to the delinquent stockholders, whether personally, by registered mail, or as provided in the bylaws. Then it will be published in a newspaper for 2 weeks. Afterwards, at the auction, whoever pays the full amount due, including all costs for the smallest number of shares, wins. Then the buyer or the new stockholders gets a new stock certificate for the shares they bought, and the remaining shares will be credited back to the delinquent stockholders. However, if no one's bid or buys the shares, the corporation itself can buy the shares, which then becomes treasury shares or the shares owned by the company itself, ensuring no financial loss to the company. The Section 68 prevents unnecessary lawsuits after the delinquent stock sales. Since if the delinquent stockholders believe that his or her shares were sold unfairly, then they must first pay or over the amount for which the shares were sold, plus interest, and file a compliant within 6 months from the sale date. Otherwise, they lost the right to question the sale. Therefore, it helps settle the issues quickly and fairly, while preventing the corporation from facing repeated or unnecessary compliance about the sales of shares that were properly conducted. Section 69 gives the corporation the right to take legal action if a stockholder refuses to pay their subscriptions or the agreement to pay a certain amount of money
in exchange for ownership of shares in the company. The corporation can go to court to collect any unpaid subscription, plus interest and expenses incurred, since it reinforces that subscribing of shares is a binding contract and the payment can be enforced through the courts to protect the corporation finances. According to Section 70, when a stockholder fails to pay their subscription on time, their privileges or stockholder rights are suspended, such as the right to vote at meetings, the right to receive notices, and the right to other privileges as stockholders. However, they may still receive dividends or the earnings from the company under certain conditions, ensuring fairness since they still own the shares even if their payment is incomplete. Their right will be just restored once full payment including interest and costs are made. That is why this provision will motivate stockholders to meet their financial duties. Now, in Section 71, it differentiates between unpaid and delinquent shares. As long as stockholders' payment is not due yet, they still have all the right of a full stockholder, such as voting, receiving dividends, and participating in corporate affairs. This will ensure fairness to those who are still within their payment schedule under subscription agreement. Under Section 7.2, both the stockholders and the corporation is protected if a certificate of stock is lost, stolen, or destroyed. Then the corporation can issue a replacement by following these steps. First, the owner must file an affidavit explaining what happened and give details about the lost certificate. Then the corporation verifies the information and publishes a notice in a newspaper once a week for 3 consecutive weeks. After 1 year, if no one contests ownership or disagrees with someone else's claim, the corporation issues a new certificate. Though the owner can get the new certificate earlier if they post a bond or security guarantee. However, if there's a court case over ownership or other claims that they own them, the corporation waits for the final judgment. Having said that, if there's fraud, bad faith, or negligence, then the corporation is not liable for replacement or issuance of a new certificate of stock.
Now let's delve to Title 8 of the Corporation Codes, which talks about the corporate books and records that every corporation must keep, including as well the right of inspection and the right to access financial statements. So, under the Section 73, corporation must keep at their principal office the important documents or what we call the corporate records, such as the following. So, first is the Articles of Incorporation and Bylaws. I know you are all familiar with this as these have been discussed from the previous session. So these are like a certificate and a rule book of a corporation, which includes all the amendments and important information of the entire corporations. So without this, a corporation cannot legally operate. Next is the ownership structure. So it simply shows who has more influence or power in corporate decisions. And additionally, is the list of directors and officers. So obviously, this contains the names, positions, and terms of people who lead and manage the corporations. So this ownership structure and list of their directors and officers helps identifying who's the decision maker, who controls the company's asset, and who reaps the benefits of its success. Now, next is the records of transactions and board resolutions. So these are simply the proof of business dealings, such as contracts, purchases, and approvals, including as well the official documented decisions of the board, or what we call the board resolutions. And next is the latest reportorial requirements. So these are the mandatory filings to be submitted to the Securities and Exchange Commission, or the CEC. So these particularly includes general informations sheet, or the GIS, the annual financial statement AFS, and other compliance documents. So take note that a failure to file these requirements can lead to penalties or loss of corporate status. Last but definitely not the least is the minutes of meetings, which must clearly show the time, date, and and place of the meetings, attendance, purpose, agenda, and the actions taken in that meeting. And any protest made must also be recorded in a full upon demand. Remember that these detailed corporate records is very essential as these protect both the company and its stakeholders by making sure everything is clear, traceable, and legitimate. Moreover, Section 73 also gives stockholders, members, and directors the right of inspections. This simply means that they can personally or through a representative inspect and request copies of corporate records, but only during reasonable business hours and at their own expense. However, the law also sets limitations to protect the corporations. For instance, competitors or anyone representing a competitor cannot access these records. And if a stockholder requests documents in bad faith or without a legitimate purpose, the corporation may refuse, and if refusal is by board resolutions, liability falls on the directors or the trustees who voted for it. On the other hand, officers who refuse inspection without valid reasons can held liable for damages and guilty of an offense punishable under Section 161 of the Code. If inspection is unjustly denied, the stockholders may report it to the Securities Exchange Commissions, which must act within 5 days. Moving on, we have here stock and transfer book and the stock transfer agent. When we say stock transfer book, it is the official corporate record that proves who owns the company. It specifically shows the complete list of stockholders, which must arrange alphabetically. It also includes the number of shares each one owns, how much of those shares have been paid or unpaid, and also the transfers or sales of shares, which details as well the when, by whom, and to whom the transfer was made. Take note that without being recorded here, a person cannot legally claim stock ownership even if they paid for share. And this is usually kept in the principal office or with a stock transfer agent. Now, when we say stock transfer agent, this is the person who's engaged in registering transfers of stocks for stock corporations. Their tasks mainly include updating the stock and the transfer book, just like what I mentioned earlier. Also, the issuing and the canceling of the stock certificates. It also includes making sure transfers follow legal and corporate rules, as well as preventing fixed stock transactions and dispute. But remember to follow these two things in order to operate in the Philippines. First, be licensed by the CEC or the Security Exchange of Commissions, and they also must pay a renewable annual fee. But corporations have two options. First, do the stock transfer themselves just by still following the same CEC rules. Second, hire a licensed stock transfer agent. And for the companies traded in the stock market, the CEC may require an independent agent to ensure transparency and prevent manipulations. Now, moving on, we have here Section 74, which simply talks about the right to financial statement. We all know that as a stockholder or members, they are considered owners of their corporations. Because of that, they have the right to know how the money of the company is being handled. So during the annual meeting, the board of directors or trustees must present a financial reporting covering the corporation's performance for the previous year, and this includes income statement, balance sheet, cash flows, and others required reports, which must all certified according to CEC standards to ensure accuracy and transparency. However, there is an exemption for small corporations. If the corporation's total assets or liabilities are less than 600,000 or another amount set by the Department of Finance, the treasurer and the president may simply certify the financial statements under oath. So instead of requiring an auditor certifications, this makes compliance easier and cheaper for very small corporations. Overall, Section 73 and 74 ensures transparency and accountability in corporations. It protects the right of stockholders and the members to access important information while also setting boundaries to prevent abuse and protect corporate confidentiality.
Let's tackle or elaborate elaborate Title IX, Merger and Consolidation. So what is merger? In Section 76, a merger happens when two or more corporations join together and one of them keep its identity. So what is consolidation? In a consolidation, two or more corporations combine to create a completely new corporation. Section 75 explains that before companies can merge or consolidate, their boards of directors must create and approve a plan. This is called the plan of merger or consolidation. There are four main things that must be in the plan. First one, the names of the corporations that want to merge or consolidate. These are called the constituent of corporations. Second, the term and steps on how the merger or consolidation will happen. This tells how they'll combine and what rules they'll follow. Third one is changes in the articles of incorporation. If it is a merger, it should show any changes in the surviving corporation's articles. But if it is a consolidation, it must include all the information needed to form a brand new or new corporation. Last one, other important details that are necessary or helpful for the merger or consolidation. Section 76. Once the board of directors or trustee of each corporation approves the plan, it must then be presented to the stockholders or members for their approval. Every stockholder or member must receive a notice of the meeting. The notice should first should clearly state the purpose of the meeting, which is to approve the plan of merger or consolidation. Second one, or lastly, is include a copy or summary of the plan itself so everyone understands what they are voting for. The law says that at least 2/3 of the stockholders for stock corporations or 2/3 of the members for non-stock corporation must vote yes to approve the plan. If a stockholder disagrees, they have what's called the right of appraisal. So what the right of appraisal means? This means that they can sell their shares back to the corporation for a fair value instead of joining the merged company. If the board later decides to cancel or abandon the plan, the right of appraisal ends. Any amendment to the plan of merger or consolidation may be made if the board of directors of all corporations agree by majority vote, and the change is also approved by at least 2/3 of the stockholders or members again. After that, the plan together with the changes becomes the official agreement of merger or consolidation. Section 77. After the stockholders or members approve the plan of merger or consolidation, the corporation must prepare an official document called the Articles of Merger or Consolidation. This document includes important details about the merger or consolidation. It must be signed by the president or vice president and certified by the secretariat of assistant of each corporation. It should contain the following information: the plan of merger or consolidation that shows the full agreement of how companies will combine, the number of shares or members. This tells how many people or shares are part of each corporation. The votes for or against plan, this shows how many supported or opposed it. The assets and liabilities, meaning the values of what each company owns and owes as of the agreed date. The method of combining their accounts, this explains how the financial records will be merged. The provisional or pro forma values, this shows that the combined company's financial situation will look like after the merger or consolidation. Lastly is other information required by the Securities and Exchange Commission.
And now, let's go on the last two sections of Title IX, Merger and Consolidation. Section 78, the effectivity of merger or consolidation. A merger or consolidation becomes effective on the date the Securities and Exchange Commission or the SEC issues a certificate of merger or consolidation. Following its satisfaction, the plan is compliant with the law. At this point, the constituent corporation became a single corporation with their separate existence ceasing. The new or surviving corporation then automatically assumes all the rights, privileges,
assets and liabilities if the original company. Section 79. Effects of merger or consolidation. The merger or consolidation shall have the following effects. A. Formation of a single corporation. In a merger, multiple corporations became a one single entity but only one of them survives and continues as the main corporation. In a consolidation, all the merging corporations are ceased and the new corporation is formed as specified in the consolidation plan. For example, when Company A and Company B merge, Company A is designated as a surviving corporation and Company B ceases to exist as a separate entity. Letter B, the existence of constituent corporations legally cease to exist, except for surviving corporation for merger and consolidated corporation for consolidation. Letter C, transfer of rights, obligations to the surviving and consolidated corporation. Rights, privileges, immunities, powers subject to all duties and liabilities of a corporation under this code. For example, if Company A and Company B merge to form a new company, all properties, pending lawsuits, and outstanding debts of both Company A and Company B are transferred to the new consolidated company. The new company is responsible for any obligation and can prosecute or defend any claims that existed against the original companies. The rights of creditors against the original corporations are not impaired by the transaction.
Section 80 talks about a situation where a stockholder may use the appraisal right. This section is very important because it gives minority stockholders a way to protect their investment when the corporation make big decisions that change the direction of the company. There are four specific situations. First one is the amendment of the Articles of Incorporation. A stockholder may dissent if the amendment changes or restricts their rights, authorize shares that have superior preferences, or extends or shortens the corporate life. These changes affect the stockholders' position in the corporation, so the law allows them to dissent. Second is the sale or transfer of all or substantially all assets. If the corporation sells, leases, exchanges, transfer, or mortgage almost all of its assets, a stockholder may use the appraisal right. Why? Because this is basically changing the entire structure and operation of the business. Number three, merger or consolidation. When the corporation merges with or is consolidated into another corporation, stockholder may not feel comfortable with the new direction. So the law gives them the option to demand payment instead of staying in the merged entity. Number four, investment of corporate funds for a non-primary purpose. If the corporation invests a large amount of money in something not part of its primary purpose, stockholder may disagree because it changes the original plan or business model of the corporation. Overall, Section 80 provides protection whenever there is a major corporate change that could affect the stockholder rights, asset, or expectations. Section 81 focuses on how a stockholder actually make use of the appraisal right. This section provides the procedure and timeline. The step-by-step process are: Step 1. The stockholder must vote against the action. During the stockholder meeting, the dissenting stockholder needs to vote no. If they vote yes or do not vote at all, they cannot use an appraisal right. Step 2. The stockholder must have a written demand. Within 30 days from the date of the vote, the stockholder must send a written demand to the corporation asking for payment of the fair value of their shares. If they fail to do this on time, they lose or waive the right. Step 3. Payment of fair value. If the corporation decides to go through with the action, the stockholder must surrender their share certificates. The corporation must then pay them the fair value of the shares. The important detail is this. The fair value is based on the price one day before the put. This prevents price manipulation caused by the corporate action. What happens if they cannot agree on the value? If within 60 days, the stockholders and corporation cannot settle on a fair price, an appraisal panel is created. This panel has three disinterested appraisers, one chosen by the stockholder, one chosen by the corporation, and a third chosen by the first two. The decision of the majority is final and binding. Another important point, the corporation can only make payment if it has unrestricted retained earnings, meaning it cannot harm the financial health of the corporation. The last part is Section 82, which explains what happened after the stockholder makes the demand and how the appraisal right ends. Effect of demand. Once a stockholder demands payment, they lose voting rights. They lose dividend rights, and all rights attached to their shares are suspended. This happens because they are already on the way out of the corporation. How the appraisal right ends. The suspension continues until one of the two things happens. The corporate action is abandoned. If the plan does not push through, the stockholder gets back all their rights. The corporation purchases the shares. Once payment is made, the stockholder is officially out of the corporation. In short, Section 82 ensures that a dissenting stockholder cannot use the rights of a normal stockholder while also asking for payment. It keeps things fair and consistent. To wrap up this, Title 10 on appraisal rights help protect stockholders from major decisions they disagree with. Section 80 explains when they can dissent. Section 81 shows how they can demand payment. And Section 82 clarifies what happens after the demand is made.
This section only explains that when a dissenting stockholder demands for a fair value payment binds them to a point of no return, which means they cannot simply change their minds or change their decision. However, there are some exceptions wherein the stockholder can withdraw the demands for payment. First will be when they change their minds and the corporation agreed. Then the right of payment ceases because this is a contractual agreement and the corporation has the right to insist on the proceedings. Second is when the SEC disapproves the proposed corporate action because a corporate action needs to be approved by the external authority to be implemented. Third is when the corporation itself abandoned the proposed corporate action because it exists when the corporation takes fundamental action. So when the action is abandoned, then there is no longer basis for the appraisal rights. Lastly is when the SEC determines that such stockholder is not entitled to appraisal rights because there are instances that the stockholder failed to comply with the procedural requirements, so the demand is void. If any of the exception arises, the stockholder shall not be paid to his fair value of his share. His status as a stockholder shall thereupon be restored, and all dividends distribution which would have been accrued on his share shall be paid to him. The general rule in this section protects the minority stockholder because by placing the cost of burden into the corporation, the law can ensure that the appraisal remedy can still be a viable tool for the minority protection against being cashed out at an unfair price. However, if the stockholder insists on an appraisal, but the final fair value is minorly different from the corporation offer, then the cost of the appraisal was not worth the small gain, then they should bear the expense. This prevents the stockholder from abusing the appraisal process, and in case of recovering the fair value, legal fees are assessed against the corporation because they refuse to pay, which is the cost of the litigation.
unless the corporation offered to pay the appraisal fair value, but the stockholder refuses the payment and sues anyway, in case the stockholder must pay the legal expense. This section requires a dissenting stockholder to submit their stock certificate to the corporation within the 10 days after demanding payment for their shares. The reason for this is to allow the corporation to place a notation on the physical certificate marking it as a dissenting shares, making it as a procedural safeguard ensuring the integrity of the capital structure and the stock transfer system. The 10-day deadline also ensures that the stockholder is serious about exiting the corporation and the proceeding with the appraisal. If the shareholder misses the deadline, the corporation can assume that claim is waived. If the shares are transferred, the original stockholder loses the right to demand fair value payment for their shares, and the new owner immediately acquires all the rights of a regular stockholder as if there is no appraisal process, and all suspended rights like dividends are reinstated in their favor.
That is all for our presentation. Thank you all for listening.